In the early morning hours of April 23, 2025, a routine commute along Interstate 275 in Wayne County, Michigan, allegedly escalated into a road rage confrontation involving a firearm. Prosecutors alleged that after a series of aggressive driving maneuvers, motorist Elizabeth Worrell looked into the adjacent lane and saw what she described as the outline of a handgun pointed directly at her vehicle. On September 10, 2025, defendant Jeremy Taylor was formally arraigned in the 34th District Court in Wayne County on charges of felony firearm under Michigan Compiled Laws, Section 750.227b, and brandishing a firearm under Section 750.234e. The investigation ultimately led authorities to Taylor, who was identified through vehicle matching and later linked to the incident. On October 15, 2025, the parties appeared before Judge Brian Oakley for a preliminary examination, where investigators testified that Taylor acknowledged the traffic dispute but denied pointing a gun, suggesting the complainant may have mistaken a finger gesture or even a coffee mug for a weapon. With no video capturing the alleged display and the complainant unable to identify the driver, the court was tasked with determining whether sufficient probable cause existed to send the case to circuit court for trial.
I have my officer in charge.
All right. This lady's not connected with the case?
She's our witness.
Oh, you're the witness? Come on up.
Yeah.
Just moral support? Come on up. Watch your step on my ramp right here. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today? Have a seat right there. Just make yourself comfortable. Mr. Kaplan, when you're ready.
Good morning. State your name for us.
Elizabeth Worrell,
How do you spell your last name?
Worrell.
And Elizabeth as in Queen Elizabeth?
Yes.
What do you do for work?
I work at a logistics company out in New Boston.
Taking you back in time to April 23 of this year, 2025, at about 6 in the morning. Do you recall your whereabouts?
I was on my way to work on 275, coming up to my exit, to get work.
What type of vehicle were you driving?
I drive like a Santa Stray, Chevy Trailblazer.
Are you alone in the vehicle or do you have company?
No, I was like, so.
You started telling the judge about you were on 275 North. Anything unusual happened to you when you were traveling on I-275 North?
I was on my way to work that morning and I noticed that there was a vehicle behind me. The vehicle was very close to the rear of my car. I had changed lanes a few different times. If I'm not mistaken, I changed lanes a total of 4 times.
Tell us about the weather. Was it light out or dark?
It was, it was typical, nighttime, right before the sun was coming up, it's about 5:30 in the morning.
Are you able, so that's I'll interrupt just because the kid was there, yes, you know it's fine. Are you able to tell the judge the color of the other vehicle?
Yes.
What's the color?
It was like a dark gray, dark blue.
Are you able to inform the court the model of the vehicle?
Yeah, it was a Chevy Malibu. License plate was the first EJ1.
How do you know the license plate was showed EJ1?
Because as he was speeding away from me, as I exited onto my exit to get off for work, he said past me at probably about 100 miles an hour. And I caught the first read license plate and the description of the vehicle.
Does anything?
Yeah, I'm gonna object to the estimate of 100 miles an hour. She actually can prove how she knows it, so
Well, that's a lay opinion, it's really not important to the case, but under 701, that's a lay opinion issue.
well, that's fine. It's not important why we're listening.
Because it's part of the investigation.
Let's move on.
Thank you. Anything more unusual happened while you're traveling at 9275 North?
When I noticed that vehicle behind me, like I said before, I had changed lanes. The vehicle followed me. I want to say it was the 3rd time that I had changed lanes. The vehicle followed me again. I did brake check the vehicle behind me, which I know you're not supposed to do.
What happened after you brake checked?
He got to get closer. And so I had moved back into the middle lane, and he was again right behind me, even closer to the floor.
Anything happened after you changed into the middle lane?
Other than him following me, no, not until I had gotten up to closer to the exit I was getting off at.
Which exit is that?
Here on exit.
Anything unusual happened there that near that accident?
Yeah, as after I had been followed back into the middle lane, I was just nervous at this point. So I waited until the last possible second, made sure that the lane next to me was clear, and I just booked it right off of the exit. And then that's when the vehicle pulled up next to me.
Anything happened when that vehicle pulled next to you?
I saw the outline of a handgun, pointed at me.
How far were you from the person holding the handgun?
The vehicle had moved right next to me in that lane, so.
Can you give us an estimate on the distance? I'm gonna walk towards you with the judge's permission. Can you stop me when I reach that distance?
Probably about right there.
Judge, may the record reflect about, I know I'm short, but about 7 feet.
Mr. Weinberg? Thank you.
Better than you said.
How certain or uncertain are you that a gun was pointed?
100% positive, I saw the outline of the handgun.
What were you thinking when the gun had been pointed at you?
That I was gonna be shot.
But what did you do, if anything, after the gun had been pointed at you?
I just got off right at that exit, and when I had looked over, the vehicle next to me had rolled the window down and pointed that gun at me. I did see the outline of the gun.
Was the gun pointed at you on one occasion or 2 different occasions?
Just once.
What do you do after the gun's pointed at you? Do you contact authorities in some way?
I had pulled into,
You're all right.
I had pulled into work, contacted my wife and, let her know what happened. She told me that with.
Can't tell us what she said.
Okay.
But anyway, you contacted
So-
your wife.
Yep, I contacted my wife. I ended up leaving work and, at the end of the road that I work off of, there was a New Boston police officer.
Did you have contact with the officer?
Yes, I pulled up next to the officer, explained what happened and asked what I do moving forward. And then that's when, he took my statement and this all began.
Are you able to identify the man with the gun?
Yeah.
Why not?
It was too dark. I couldn't see the face. The only thing I could see was the outline.
Mr. Weinberg, your witness.
Sorry.
Sure.
Sorry, that's bolstered.
Sure.
I'm just kidding. I'm sorry, what was your name?
Elizabeth, Laura.
Elizabeth, my name is Scott Wayne. I'm going to ask you a couple questions. If you don't understand them, let me know. I'll stop it when I'll rephrase it, okay? Sure, you stand. Sir, can you identify that man at the table? You cannot identify my client, Mr. Jeremy Taylor, is that correct?
Objection's been asked today. Is
that correct? You can't.
been an objection asked.
Clarification.
So you have no idea when Mr. Taylor was the man you're talking about that day, correct?
No.
Correct. And it was too dark to identify him. Is that correct? What kind of day was it?
5:30 roughly in the morning.
5:30 in the morning, so it was dark. When did you claim that he actually pulled up next to you? Was the light in his vehicle on?
No, the lights on the, other side of the freeway, that's how I could see that that's a I could not see
Okay,
his face.
okay. So you did not see a gun, you saw the outline of the gun, correct?
Right.
You can't identify the gun, correct? Can't identify the model or make, correct? You saw an outline of what you thought was a gun, correct?
Of what was gun, yes.
Well, did you ever touch that gun? You can't identify anything other than the outline, correct? Right. Have you ever seen a gun close up before?
Yes.
Okay, do you own a gun?
No, I do not.
Okay. You ever seen the outline of a handgun like this gun before?
To me, handguns for the most part look the same.
Did you understand my question?
Yes.
My question was, did you ever see an outline of that specific gun before?
I can't answer that.
Was that a yes or no?
Objection, she said she can't even
No.
question.
Answer that.
You testified that this was a road rage type of situation, correct?
Yes.
And at some point, you slammed your brakes on in front of him while you were driving, isn't that correct?
Correct.
And that would precipitated this incident, correct?
We object, she doesn't know what you said.
No.
Well, you're right.
Excuse me, we don't know what's in the mind of the other person?
That's fine,
So that was a speculation objection?
Yeah.
Response?
I believe that maybe Mr. Kaplan doesn't understand. Yeah, I believe the witness understands. Did you understand that question?
We object, I didn't say that, we started to understand.
You're asking her, let's rephrase that.
So I'll rephrase.
Was that the first incident between you and the other vehicles when you brake checked the vehicle?
That morning, did you make a statement to the police?
Yes.
And again, did you tell them at that time that you could not identify the man or the person who allegedly pointed a gun at you?
Yes,
Okay. And did you ever tell the police that you heard this man say anything?
oh,
So you can't identify his voice either, is that correct?
correct,
You can't identify anything other than you saw the outline of what you think was a gun, correct?
correct.
Right. I go for this.
Any follow-up?
Thank you, Your Honor. No further questions.
Ma'am, you can step down. Watch your step on my ramp.
At this point, the hearing turned toward a question that appears in nearly every preliminary examination. Not whether the defendant is guilty, but whether enough evidence exists for the case to move forward. Under Michigan compiled laws, section 766.13, the court must determine both that a felony may have been committed and that there is probable cause to believe the defendant committed it before the case can be bound over for trial. That standard became significant here because Ms. Worrell remained certain that she saw the outline of a handgun, yet she also acknowledged that she never saw the driver's face and could not identify the specific firearm involved. Those limitations do not automatically defeat the prosecution's case, but they do affect how strongly the evidence connects Jeremy Taylor to the alleged offense. The prosecution would soon attempt to bridge that gap through the testimony of the investigating trooper and the vehicle identification evidence gathered during the investigation.
Your Honor, we have one other witness. We'll call him, and that's our trooper, Trooper Jonathan Meyer.
Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth today.
I do, sir.
Settle in. When you're ready, Mr. Campbell.
Thank you, Your Honor. Good morning, Trooper Meyer.
Morning.
Sir, how many years have you worked in Michigan State Police?
13.
So were you working on April 23 of 2025?
Yes.
Can you tell the judge where I-275 near South Huron Road, what municipalities in that area?
New Boston
In which county?
in Wayne County.
Well, sir, did you have an opportunity to speak to a woman named Elizabeth Morrell?
I did.
She's the woman who testified a few moments.
That's right.
Why did you speak to Ms. Morrell?
Miss Worrell explained to us that she was.
Don't tell us what she said. I just want to know where you spoke to her.
Where I spoke?
Yeah.
I'm sorry. That would have been on Huron Avenue, right there, just west of I-275. She had left the workplace to come to meet with us there.
Did you know Ms. Morrell before the state?
No,
How long did you speak to Ms. Morrell?
probably approximately an hour.
How did you become involved in this custody?
Our dispatch center was contacted by the New Boston Police Department requesting that we make the scene to handle the incident with the others.
How much time passed between when dispatch received information about an alleged crime on the freeway and when you met with Ms. Morrell?
I would say approximately 30 minutes.
Trooper Meyer, did you meet a man named Jeremy Taylor?
Yes.
If you saw Jeremy Taylor again, you recognize him?
Yeah,
Look around the courtroom and let us honor know whether you see Jeremy Taylor.
I do, yes, sir.
What is he wearing and where is he seated?
He is seated next to the defense attorney, wearing a maroon shirt and a kangaroo on his neck.
Noted.
Thank you, Your Honor. Why did you speak to Mr. Taylor?
Mr. Taylor was my suspect, the registered owner of a vehicle matching the description given by the victim.
Oh, you provided me a license plate, partial license plate number?
That's right.
What, do you remember what that is?
It was EJY with the first three.
Who provided that to you?
Miss Laurel.
In terms of that EJY 275 partial license plate description, did you attempt to determine the owner of the vehicle?
Yes.
How did you do that?
Using our license plate reader cameras in the area, I conducted a search using the criteria provided, partial plate along with a vague vehicle description, and was able to come up with two possible matches to that.
Ultimately, you narrow the field?
Yes, sir.
Who do you narrow?
I'm sorry. Who?
Who do you narrow the field? Who's left? In terms of the EJY license,
Yeah.
you determine who
Yes, sir.
played?
Yes, sir. So from those license plate reader camera photographs taken of that vehicle, I was able to retrieve that full license plate, run that license plate through our law enforcement information network.
And through lean,
Yes.
did it identify anybody?
I did, yes.
Whom did it identify?
It was Mr. Taylor as the registered owner of that vehicle.
You know his first name?
Jeremy?
Did you make any determination as to whether Mr. Taylor, in fact, drove such a vehicle?
Yes.
And what was the vehicle? Were you able to tell us the color and model and year?
Yeah, it's a blue, I believe, 2009 Chevy Malibu.
Ultimately, I'm gonna skip ahead for a moment. Did you at any point advise Mr. Taylor of his Miranda rights?
I did, yes.
How did that,
Traffic stop was conducted.
by who?
I did. And I pulled him over on 275 near Eureka. Spoke to him briefly, introduced myself, asked him if there were, or he declared to me, rather, I didn't have to ask, he declared to me that there was a firearm in the vehicle, that he was a CPL holder. Shortly thereafter, I read him his Miranda rights, took him into custody.
So don't go any further.
Yes, sir.
There was the Miranda rights.
Yes,
Comprising of such rights, did you do so from your memory or from a form?
that's read to him from the form. I read it to him from the form.
Can you estimate for Judge Oakley the number of times you've read Miranda rights to suspects?
I would say, fair estimate would be several hundred times.
In doing so, in this case, did you read some of the rights, all the rights, or none of the rights to you?
All,
How long did you speak to Mr. Taylor?
I would say, I would, an estimate approximately an hour.
Now, after reading him his rights, did you ask whether he wished to speak to a lawyer?
I'm sorry, what was
Did
it?
you ask wanted a lawyer or whether he wished to remain silent?
Yes,
What was his response?
he agreed to talk. He said he would his rights to talk.
Did you offer him any promises of leniency to speak to you?
No, sir.
Did you threaten him in any way?
No, sir.
Did he appear to be deprived of food, water, shelter, sustenance, or sleep?
No, sir.
Then you took the spoke.
That's right.
But what if any, did you inquire as to where, his whereabouts earlier in the day, like April 23, 2025, at about 6 in the morning?
Yes, I did.
What did he tell you his whereabouts?
He explained that he was traveling on northbound 275 on his way to work at approximately that time.
Did he indicate where he was headed, where he was coming from?
He was coming from his home and headed to his workplace, in Van Buren Township.
Did you inquire about any incident that might have occurred between two vehicles?
I did.
What's the specific question you asked him?
I asked if there was any unusual road rage type incidents that had occurred then.
What did Mr. Taylor say in response?
Initially, he denied that there was, saying that something had happened the day prior.
You said initially he did.
That's right.
What does that mean?
So when I first asked, that question, had anything unusual, like a road rage incident happened, he said, no, not this morning. Yesterday, something happened between me and a female in a light colored vehicle.
Does he give a different answer at some point?
He does, yeah.
How does the transition occur?
So I asked further questions about that incident. And I said, well, there was an allegation that something happened this morning. And then he said something along the line of, oh, maybe that was this morning. And then goes on to describe the victim's vehicle and, somewhat of a road rage interaction between them.
Did he indicate to you any specific actions he claimed that the other woman took?
To my memory, that she brake checked him and flipped him off,
What is slipping off?
presenting her middle finger to him, a derogatory manner.
Did you specifically ask him whether he pointed a gun at another moment?
I did, yes.
What did he say?
He denied it.
Does he later give an explanation?
He does.
What does he say?
He said that it could have been that what she saw was him pointing his finger at her, and then later added that he may have had a coffee mug in his hand at the time he pointed his.
You indicated to the judge earlier in the direct examination about this saying he had a conflict.
Yes.
Did you find a gun?
Yes.
Where you located a gun?
In the center console between the driver's and passenger seat of the vehicle.
How far is that gun from the driver? Where the driver would have been seated?
Directly next to him, within arm's reach.
The information you had been given about the vehicle, latest vehicle, does that match or not match the vehicle you saw the defendant?
It does.
How does it match?
The first three of the license plate match, and also she described the color and model of vehicle along with bumper stickers stretching from one tail light to the other across the
If
back.
those coincide or not coincide with the vehicle you noticed,
Those all coincide.
what happened to the gun?
The gun was seized from the scene of the traffic stop and put into property at the Metro South Post.
Are you familiar with the term holstered gun?
Yes,
gun being holstered?
yes.
What does that term mean?
That means, secured in a holster for carrying the firearm.
When you recovered the gun from the center console, was it holstered or unholstered?
I do not recall.
Would your report refresh your memory?
Yes,
Do you have your report with you?
I do not.
Judge, do I have permission to approach the witness and have him review his report?
Sure.
Thank you, Your Honor. Read it yourself to provide
Yes, sir.
safety.
Thank you.
I didn't underline this. I don't know any specific page.
Understood.
Oh, I'm sorry. Did you get a chance to read
I
the
did.
report?
Yes.
Judge, do I have permission to retrieve the document?
You do.
Please remember the document. No, it's been critical. What is your memory tell?
That in fact, the firearm was in the center console, unholstered.
Was the firearm loaded or unloaded?
It was loaded, magazine full.
If you investigated shootings in your career,
I have, yes.
tell the judge, and probably knows, a gun, which is more readily usable, a gun that is holstered or a gun that is unholstered?
Unholstered.
Thank you, Your Honor.
Mr. Weinberg.
Supervisor Scott, my work will ask you some questions if you don't understand something. Let me know. Yes, sir. So you were called onto the scene by other police officers. Who else was first on the scene?
That would have been two Boston.
So this wasn't a car, yours was pulled over by a speaker.
That's correct. Yes.
And when you got to the scene, where was my client?
That was unknown to me at the time where we planned this.
And at some point, well, let me back. Did you pull my client over?
Yes.
You pulled him over.
Later that afternoon, yes, sir.
So when you pulled him over, you pulled him over because of this match on weight, correct?
That's correct, yeah.
And, did you first approach my client's car?
I did, yes.
And was he in the driver's seat?
He was.
And he, as you testified, first told you, right when you came out, that he had a CPO, correct?
That's right.
That he was obligated to do.
That's right.
You didn't see him on the gun.
I did not see the gun at first contact.
And in no time did he provide you with the gun, correct?
He did not provide me, as in hand me the gun, no, sir.
Right. So who actually ended up pulling the gun out of the car? Who found it?
To my recollection, I found it located.
Do you remember whether I searched and found the gun in here?
Yes. Now, I had two other troopers with me, so that's why I say to my recollection, I'm the one who pulled it out of the Senate Council.
And did you pull it out before or after you interviewed my client?
During, well, I don't remember how many questions had been asked of him, prior to us removing the weapon from the vehicle.
But you had already interviewed him, correct? For so,
I had spoken to him, yes, that's right.
and you read his Miranda rules.
That's right.
And at any point, did you take my client, put him in your vehicle, and start discussing this matter, interviewing him without reading his Miranda rules?
No, he had been read his parental rights prior to.
And you only read it once, correct?
That's right.
And when you read it to him, where were you?
Standing on the side of the freeway,
Where was he?
also standing there with me.
Outside of you.
That's right.
Well, when you first started, when you first arrived at the scene, isn't it true that you took him out of his vehicle and had him sit in your squad car, correct?
I don't recall at what time in the time or when in the time frame he sat in my vehicle, but he did sit in my vehicle. That's right.
And had when he was in your vehicle. Is that when you read his Miranda rights or is it after?
I don't recall.
Could you recall getting a statement from him after you read his Miranda?
That's, yes,
It was clear.
yes,
Do you recall your conversation when you spoke?
I do.
Do you recall the questions and the comments you made to him when you were interviewing?
Not every comment, no, I'm sure not.
But you remember your conversation.
Yes.
And you recall telling him the rendition of what was her name, the complainant?
Miss Laurel.
Miss Morel, what she had told you or what your understanding is of what the complaint was?
Yeah.
And that there was some type of pointing the gun at her, correct?
Right, yes.
Isn't it true that you told him that he was involved in an accident with this woman? Do you recall that?
I don't recall.
Do you recall telling him that there was evidence to show that he actually did point the gun at her?
Yes.
From a video camera?
That's right.
Do you have any evidence of that?
No, sir.
So you lied to him about it?
Yes, sir.
And is it your practice to lie?
Objection, he's allowed to lie.
Well, I'm asking,
He can be Pinocchio, it doesn't matter. He can say whatever he wants.
I understand that, and I agree with you, but that doesn't mean Mr. Weinberg can't ask me questions about it.
As the cross-examination continued, the defense turned its attention to the methods used during the investigation itself. Trooper Meyer acknowledged that he told Jeremy Taylor there was evidence showing a gun had been pointed at the complainant, even though no such evidence actually existed. While investigators are generally permitted to use certain deceptive tactics during interviews, the admission gave the defense an opportunity to question the reliability of the statements that followed. Prosecutors maintained that the interview remained lawful and that Taylor never confessed to pointing a firearm, but the exchange exposed a growing dispute over how much weight the court should give to the defendant's evolving explanations. In a case already built largely on witness observations and circumstantial evidence, that disagreement added another layer to the probable cause analysis before the court. In your opinion, where should the line be drawn between effective investigative tactics and conduct that risks undermining confidence in the evidence?
So is it your practice to lie to a suspect during the investigation?
We object to that question. It doesn't matter what his practice is. It could have been the first time he lied, or he lies all the time. It's not relevant.
That would be an irrelevant. Go ahead. Relevance objection.
It's not only relevant, rather, it's also goes to his experience and his practice as a trooper. The prosecutor went into excruciating detail about how many types of stops he had, whether or not he's had gun types of investigations, whether or not he loaded, how he knows is it practical to have something on his hip if it's holstered or not. I'm just going by his practice in terms of interviewing witnesses.
You're stretching, but I'll allow it.
So is it your practice to lie to a suspect while you're doing an investigation?
It's not necessarily my practice, no, sir.
But you chose to do that in this.
Yes,
And you knew that, I can't remember it, was Miss Swan,
that's right.
Warren, just for the record, is it, how do you spell? Oh, W-O-R-R. Warren. Isn't it because Miss Warren could not identify my, isn't that correct?
I'm sorry, what is the?
You had told him and lied to him that there was evidence to show that he pointed the gun other than Miss Warren, saying that someone pointed a gun because she could not identify my client. Isn't that correct?
Well, checking the question, I'm still analyzing to understand.
Well, did you understand the truth?
I'm struggling to understand the question.
So let me rephrase. Why did you lie to my client about the picture showing that a picture that didn't exist, showing that he pointed a gun?
Just relevancy, it doesn't prove or disprove anything in the contrary.
What's the relevance?
Relevance. Why he was trying to get my client to admit something.
Well, I'll take judicial notice that it seems to have worked, if that helps.
Well, did it? Did he say that he agreed that he actually did point a gun?
No, sir.
So he denied it.
That's right.
At any time, before you read his Miranda rights or after you read his Miranda rights, did he ever say that he pointed a gun?
He did not.
In fact, he did say that he might have pointed his finger or a cup. Isn't that correct?
That's right.
And did you hear Ms. Worrell's testimony today?
I did.
And you,
Josh, you can't comment on another witness's testimony.
I didn't ask him about it. I just asked him if he heard.
That's not relevant.
So you did hear.
Objection, there's an objection on the table.
So let me ask you this.
Go ahead.
Besides Ms. Worrell saying she saw an outline of a gun, is there any evidence you collected showing that my client pointed a gun at Ms. Worrell?
No, sir.
Do you recall whether or not your squad car had a video on the set?
It does, yes.
And do you recall whether that recorded any of your conversation with my client in your vehicle?
Yes.
And you recall whether or not, had you reviewed that movie?
It has been some time. I reviewed it either that day or that week.
But it's your sworn testimony that prior to interviewing my client in that vehicle or outside the vehicle or any time that day, that you read his Miranda rights, correct?
Yes, I read him his Miranda.
I have no further questions.
Mr. Kaplan, any redirect?
Thank you, Your Honor. Can you demonstrate for the judge that did the defendant make any gesture when he described possibly pointing his finger at the moment?
He did, yes.
Can you show the judge, stand up and show the judge the gesture of the
Yes. He said that he may have pointed his finger and did something like this.
So for the record, can we agree that the trooper has stood up and pointed his index finger with his thumb closed? An apt description?
nothing?
All right, and you recross. Trooper, you can step down. Watch your step on the ramp.
Your Honor, before enough.
Any defense witnesses? Argument?
Running an interesting case before you, and we have a very good defense lawyer. Judge, in this case, the witness says a gun was pointed at her. Could she be mistaken? Yes, she could be mistaken. The question is the probable cause of the gun was pointed at. She seems certain, Judge, despite a very effective cross-examination by Mr. Weinberg, She said that was a gun. I saw the outline of the gun. I've seen guns. That was a description. Now, in terms of who the culprit is, whoever did this, Judge, allegedly did it. He's driving a dark colored Chevrolet Malibu with the first three digits of the license plate being EJ. Now think about that, Your Honor. Think of the coincidence if he's got the right guy. And he's somebody else driving a dark colored Chevrolet Malibu in that area on I-275 North was involved in this license plate links him. Can I say to you, and you said this family, you're 100% sure? No, but think of the likelihood of this license plate featuring EJY and it being a dark colored Chevrolet Malibu. And he had a gun in the car. And it wasn't holstered. Now that's important. It means it's readily accessible. This was a low-grade incident that spiraled out of control, and it's very unfortunate, but fortunately, nobody was injured. And the finger, once he thinks he's been nailed, oh yeah, they might have some video, they might have something where I'm pointing the gun, so, maybe it was my finger. That's not something you forget, Judge. It wasn't as though he had been interviewed weeks later. Yeah, maybe he had quite enough finger. We would ask around to find the case, so where's Judge?
Mr. Weinberg.
Thank you, Judge. Well, I will go by a much better prosecutor than I may be as a defense attorney, but it can't just be, he could be mistaken. This man is charged with a forgery felony and a mandatory 2-year felony firearm. They better have more than simply, she could be mistaken. She did not identify a gun. They had no pictures of a gun. They had never identified any gun that she identified. They never had any evidence said, yes, that's the gun that was used, or this is what the gun looked like. It was an outline of a gun where she readily admitted it was too dark even to identify my client. It was at 5-something in the morning. There's no lights other than maybe some street lights. She has an extremely weak testimony in this matter. But for the grace of God, go us in this kind of case. If someone can just drive up and say that they actually saw someone with a gun and they get them charged with this. So I disagree with this experienced prosecutor who's handled thousands of these cases that there is enough evidence to bind my client over. Maybe if they had the gun, maybe if they had or even identify my client as the driver of the car, but they don't even have that. So I'm asking the court to dismiss this.
Go ahead.
And reviewing, this very night, but in reviewing the case, they're determining whether there's probable cause to believe the crime occurred. And there's more than probable cause here. Maybe
I don't see any way in hell of getting a conviction, but the probable cause burden has been met. I'm tempted to dismiss it just so we don't waste any more judicial resources, but that's not my role. I'm going to bind it over.
Thank you. Thank you.
AOI is October 29. October 29, 9 a.m. Bond will continue. Good luck downtown, gentlemen.
Thank you.
At the conclusion of the preliminary examination, Judge Oakley ultimately concluded that while the evidentiary record may fall short of establishing certainty for conviction, it was enough under the legal standard to bind the matter over for Circuit Court review. The case was then transferred to the Third Circuit Court, where it was assigned to Judge Shannon Walker. On December 17th, 2025, Jeremy Taylor entered a plea of nolo contendere to the charge of brandishing a firearm in public, while the separate felony firearm count was dismissed as part of the resolution. Judge Walker ultimately sentenced him to 2 years of probation, 160 hours of community service, and the payment of court costs and fees. The outcome marked a procedural shift from contested allegations toward negotiated resolution, where the focus moved away from trial and toward sentencing structure and compliance. And in the end, the case closed not with a jury verdict, but with a plea agreement. And in cases like this, where perception, interpretation, and proof never fully align, how should viewers weigh the difference between what is alleged, what is proven, and what is ultimately resolved? Anyway, if you enjoyed our audit on this case, make sure to like this video and subscribe to your trial court for more videos like this. We love to make videos for you. Thank you.